Well, I think this is a fairly logical position to take. Somebody's using somebody else's property. The owner of the property says, well, I'm willing to let you do it, but you must pay me a fee. Uh, I- It really is no different from going into somebody's house. The landlord doesn't let you in unless you're prepared to pay the rent. And that's what it boils down to. I mean, we would get the same result in the United Kingdom by, I think, a more direct and I think a more logical route, and actually a better route, legally speaking. You may not think much of our procedure in Germany, but we think we've got a. But the legal route is a better route. We put aside competition law altogether. We say, when you promise a license, governed by French law, the promise is binding. Third parties can take advantage of it. Contractual. Same route as the Americans have taken on things. But of course, you have to apply the law of the contract. The reason that baffle me they haven't done that in France is a straightforward thing. You look at the contract. I promise to license you, and we get out of another thing if you do that. You don't even look at whether it's a counter offer. The only thing that matters is whether the patentee has made a FRAND offer. That's what he's promised to do. If he's done it, he's done his job. If the defendant doesn't take it, too bad. He can negotiate, of course, but you don't have to look at the negotiations, because that's one thing English courts don't like looking at, because we can't second guess commercial men. But you'll get the same result. And I think Cordula made a really important point, which is it is anti-competitive if some people pay and some people don't. But that's a position that's actually got to happen in the world. It's no good. I mean, you could try and use a European court or an American court, but really, this is for the world. And sooner or later, there will be a world system for fixing these things. At least I think there ought to be.